Hello, my name is Kate Dittrich, and I am a labor and employment attorney that's going to talk about medical issues in the workplace, specifically accommodations, different types of leave, and privacy issues, and the laws that govern those topics. They're usually governed by one of the following laws that are on this slide here. The difficult part about these issues is that there's not one overarching law that governs everything. And sometimes these laws conflict. So knowing which topics each law covers and how they work together and where the conflicts lie will be helpful in administrating accommodations and leaves and privacy issues in your workplace. We're going to talk about these laws and how they govern the workplace. The first three are at the federal level: the Americans with Disabilities Act, the Family Medical Leave Act, and the OSHA Act govern workplaces all across the country. Workmen's compensation law is a state issue that is administered state by state. And then the last thing we'll talk about are internal policies and third-party benefit coverage. So the Americans with Disabilities Act, the ADA-AA, it has been amended, and so now it's referred to as the Americans with Disabilities Act Amendments Act. And it has two main components. One is that it requires non-discrimination, and two is that it requires accommodations that enable the employees to perform the functions of their job. So sometimes that includes a leave of absence if the leave would enable the employee to heal, recover from whatever illness or injury they're suffering from, and then perform the functions of the job after their recovery. And that also includes privacy components. These govern a much more broad range of employers than HIPAA. One of the biggest misstatements of employers is that's a HIPAA issue. That's a HIPAA issue. And usually a HIPAA concern is one that is for companies that regularly process healthcare information. So hospitals, doctor's office, insurance companies. Most private employers are not covered by HIPAA, but they are covered by the Americans with Disabilities Act, which has the privacy components that we're going to talk about today. The Family Medical Leave Act is one that most people are familiar with, FMLA, and this provides 12 weeks of leave for eligible employees for various health concerns for yourself, for family members, and for military reasons. So we're going to drill those down in a little bit here. And then OSHA, the Occupational Safety and Health Act, requires safety standards in the workplace. There's certain requirements about record keeping and logs that employers have to take, and requires certain standards to be met in the work environment. Then the workers' compensation law requires employers provide medical insurance and related costs for any workplace injuries that happen in the workplace. And then we'll talk a little bit about internal policies and third-party benefit coverage, which allow for paid time off and short-term and long-term disability benefits. So the ADA, we'll start with this one. This is the federal law that governs most every employer, anyone with 15 or more employees. And this was significantly expanded several years ago to broaden the definition of disability. A lot of times folks think about disability as something that someone was born with, you know, if someone's wheelchair bound from birth or something to that effect. But really a disability is defined as any impairment that substantially limits a major life activity for any amount of time. So if you break your leg skiing in Colorado, you are disabled for the time period that you're in a cast or that your leg is healing, because you would be substantially limited in the major life activity of walking or driving or doing things with your legs. Once the Americans with Disabilities Act was amended, it now covers temporary disabilities. Previously, there was a rough time frame that said, okay, if you're not born with a disability, it has to last generally over 6 months, and that is now gone with the Amendments Act that says that a disability is any time that you are substantially limited in a major life activity. It also covers alcoholism and prior drug addictions. They are considered disabilities. Now, this does not mean that you have to allow your employees to come to work intoxicated to accommodate a disability. Again, an accommodation is to enable the employee to perform the functions of their job. But you can't terminate someone simply because they are an alcoholic or simply because they are a drug addict. And you may have to provide accommodations in the way of adjusted schedule if the person needs to go to meetings or get any treatment for those conditions. Depression and anxiety are two topics that come up quite a bit that employers tend to miss, that those can be considered disabilities. And when you're assessing whether it's a disability, you would look at, or a doctor would look at, whether or not the condition substantially limits a major life activity. So if someone is depressed, but they can still function, they still go to work, they still socialize, they still engage in normal life activities, then it wouldn't be considered a disability. However, if someone is depressed to the extent that they can't get out of bed in the morning, or they have extreme difficulty interacting with others, then it can constitute a disability. And in that case, if the employee needs something to enable the employee to perform the functions of their job, then an employer would have to do that as long as it doesn't cause an undue hardship on the employer. So words to pay attention to. So these are the ones where a lot of times managers completely miss or don't think of these issues as something that could be disabling. So if you hear an employee say that they're so stressed, or they have severe anxiety or depression, they can't sleep, they're not eating, or my doctor said this, or my therapist said this, that's when flags should go up to say, hang on a second, is there something that this employee needs in order to perform the functions of their job? Now, we're going to talk about privacy issues in a little bit of where that line is of what to question the employee on. But as a baseline rule, what we want managers to do is to open the door to employees. So if you hear these words, I'm so stressed, I have so much anxiety, I can't sleep, my therapist said this, or my doctor said this, the next response from the manager's mouth should be something to the effect of, is there anything you need from me, from the company, that would help you do your job? Okay. That opening the door is really what's required of employers to start what's called the interactive process, which means assessing if the employee does have workplace limitations and what is needed for the employee to perform the functions of the job. Okay. A lot of managers err on the other side of protecting employees' privacy, or they think, oh, HIPAA is governing this. Okay. Well, again, as we talked about at the beginning, most employers are not governed by HIPAA, but there are confidentiality and privacy concerns at play, but that should not keep a manager from saying, hey, do you need anything? Okay. A lot of times managers say, no, I don't want to hear any medical issues. Go talk to HR. Okay. And the problem with that is twofold. One, it makes an employee think that the manager doesn't care about them on a personal level, okay? And two, they feel dismissed, right? They're not engaging in the interactive process with the manager, which is required by law. So where that balance is for the manager to say, you know, I want to respect your privacy. So I want to limit my questions here, but I do want to make sure that you have what you need in order to do your job. And is there anything that you do need of me or of the organization in order to perform the functions of your job? Okay, and see how the employee responds to that. So a reasonable accommodation is required to enable the employee to perform the functions of their job. It's not an excuse from performing the functions of your job. And that's where a lot of employees get confused. So you may have an employee who says, I have severe depression and insomnia, and I need to have a flexible start time. I need to just come to work whenever I can get up in the morning because my two conditions cause a lot of sleeping problems and I never know if I'm going to be able to get up or not. Okay. So in that case, what the employee is essentially asking is an excuse from a predictable start time. Okay. And maybe that is fine. Maybe you have a position that, an employee is just processing paperwork or doing some data entry, and it really doesn't matter when that work gets done. In that situation, you're not excusing them from performing the job because they're going to perform it just at a later part in the day, okay? But most positions require regular and predictable attendance. So for example, if you are a maintenance staff, if you have a maintenance employee who is set to cover a certain time period in case of emergencies, a water leak or something else that requires physical presence, then regular and predictable attendance is going to be an essential function of the job. And so just saying you can come into work whenever you want is not going to work. Okay, that would be excusing the employee from performing the functions of their job. So in that case, you would say, okay, we can't have you come in anytime, but we can sit down and talk about whether this schedule is feasible for you. Normally, if you have trouble waking, you never know quite when you're going to wake up in the morning, maybe we schedule you to start at noon and work from noon till 8. So we can have regular and predictable attendance and know when you're going to show up to work, and the employee can adjust to whatever sleeping problems that the employee has that are causing the employee to not be able to sleep. Okay. So employers are required to engage in that interactive process. And that means just assessing what the employee needs and what the employer can do without an undue hardship. It requires that medical information be kept confidential. Okay, so here's the balance there. Here is what the ADA requires. It does say that information on employees and applicants needs to be maintained on a separate form in a separate medical file and be treated as confidential, except supervisors and managers can be informed regarding necessary restrictions in work or the duties of the employee and necessary accommodations. Okay, so that first a subsection there is really the interactive process. Okay, this is what allows managers and supervisors to talk to the employees about what's going on, what are your limitations, and what your needs are. Okay, then there's also provisions that say first aid and safety personnel may be informed when appropriate about if there's a disability that might require emergency treatment. So if you have an employee that has seizures or an extreme allergy and needs medication to be brought to them if they are having an episode or something to that effect, then you can inform someone who is responsible for safety and for first aid that the person might need some assistance on that front. Okay. And then government officials who are investigating compliance with the ADA must be provided with relative information on request. Okay. So this is, instead of the world of HIPAA, this is the world that governs most workplaces that says any information must be kept confidential if it is related to the employee's health. Well, while the ADA requires medical information be kept confidential, OSHA, the Occupational Safety and Health Act, requires that employers maintain a safe work environment, which may include informing others that an employee has contracted a contagious disease. This is really where the conflict arises, especially with regard to COVID-19 coronavirus that we're dealing with right now during the pandemic that we have been dealing with for several years. So the OSHA requirements that you maintain a safe workplace might dictate that you inform employees if they've had been in contact with someone who has tested positive or who has been exposed to COVID-19. You also have the ADA confidentiality requirements on the other side of that, okay? So to rectify those two, we generally recommend that an employer says, you have been in contact with someone at work who has contracted COVID-19. So you should monitor your symptoms, or in certain cases, they may need to quarantine, but without disclosing that individual's name. Now, in most cases, 9 times out of 10, the employee is going to put 2 and 2 together and say, oh, so-and-so is missing from work, and I was just informed that I have been exposed, so it must be this person who has COVID-19. That's fine. That's fine if the employee puts those two things together. But what's important for the employer is to try to maintain that balance of protecting the employee's privacy while also keeping a safe workplace. In certain circumstances, it may be required to notify an employee or talk to an employee about a specific person if you can't otherwise contact trace, if you can't figure out who this employee was around, if the employee is hospitalized and unable to communicate with the employer about who they were around. So there's certain circumstances when a specific name of an individual may need to be disclosed, but for the baseline rule, what's best is to just simply say one of your coworkers or someone who was in the workplace has contracted the coronavirus, and we recommend that you take certain steps to monitor your symptoms or quarantine if that's something that needs to be done. Okay. This next slide has examples of reasonable accommodations. So things that an employee may need in order to perform the functions of their job. Now, oftentimes an employee doesn't know what they need. An employee knows what the problem is, but doesn't know what a solution is. And generally it's on the employee to figure out what the proposed solution is, or the employee's healthcare provider to figure out what the proposed solution is. But you as the employer could talk to them as well to say, okay, maybe this will work or maybe that will work, because you are required to engage in that interactive process to assess accommodations. So some examples are making facilities accessible. That's one that most people would think of off the top of their head. So making ramps, lowering light switches, having remote control doors, or doors that you can wave open, and faucets that you can wave open, that are motion censored. Job restructuring, modified work schedules are sometimes things that managers don't think about, but that are things that you may need to do as an employer to provide an accommodation. Acquiring or adjusting equipment is something that may need to be done, or changing materials or policies. Providing readers or interpreters. Usually this is if there is a one-time event or a conference or something that is not the usual day-to-day. Usually the law holds that if an employee needs an interpreter 24/7 to do their job, then that's something that the employee would have to pay for. It would generally rise to the level of an undue burden on the employer. But if it's a single event, such as, okay, we have someone who is, say this individual is hearing impaired, but they are working in a financial position where they're doing data entry and they don't need to communicate with others. They work basically on paper and on their computer, but there's a conference call that they need to be a part of to figure out, how the department's going to be reorganized or something to that effect. If that one-time thing is occurring, that's where you may need to provide an interpreter, someone who can sign or dictate and type out the conversation as it is going. And then a leave of absence is another thing that a lot of times employers don't think about as an accommodation, because again, it's supposed to enable the employee to perform the functions of their job rather than excuse the employee. But the case law has held that leaves of absence can enable the employee, if they're given that certain time frame, then it enables them to come back to work and to perform the functions of their job. This is a slide I like to show everyone to really help folks understand that accommodations are giving the employee a step up, okay? So a lot of times when we talk about the discrimination laws and we talk about treating people consistently and treating people fairly, everyone has in their head, okay, we're gonna treat people equally. Everything's gonna be the same. And in the disability world, that's not quite what we need to do, because if we treat everyone the same, then there are individuals who are still at a disadvantage. So what we really want to do is practice equity and attempt to put people on an equal playing field after the accommodation has been made. Okay, so that might require giving someone a step up, maybe a parking spot that's close to the entrance of the building, or something that you would see as an extra benefit, but that enables the employee then to be on equal playing field with the other coworkers. Leave entitlements are easily confused with paid benefits. So I want to talk about this issue a little bit, because a lot of times people will say, oh, they're on workers' comp leave or they're on short-term disability. And those things are really not a leave entitlement. What a leave is simply time away from work. It's where the employer says, okay, you can be gone and your job will be there when you come back. Okay, that's a leave requirement. So the leaves under the Americans with Disabilities Act or the Family Medical Leave Act provide job protection. That's what that word means, is job protection when you say the word leave. Okay. But there are other benefits that are provided to employees while they're on leave. So if you have an approved time away from work, that may be because you were injured in the workplace. And if you were injured in the workplace, then you're going to get workers' compensation benefits while you are approved to be gone. Okay. Same with short-term disability. That's a wage replacement benefit, or vacation, PTO, sick leave, sick pay. Those are things that are simply replace your wages, but don't protect your job. Okay. So there's no law that says if you are receiving workers' compensation benefits, your employer has to hold your job for you. Okay. The benefit is provided if your job is being held and you're on approved time away from work. Okay. So leaves covered by the Family Medical Leave Act. So we're going to talk next about the FMLA, which is again the federal law that governs leaves of absence. It covers a few different things that we'll go through briefly. So the first is the employee's own serious health condition. Now, the regulations on this are several pages long and 8-point font that govern what is a serious health condition. And for managers, that's not something that you need to be assessing. That's something that human resources and the healthcare providers can assess. But the Cliff Note version is on this slide. So hospitalization will generally be covered under FMLA. Any incapacity of more than 3 days plus continuing treatment is generally covered. Chronic conditions and permanent or long-term conditions are also covered. So as a rule of thumb, I'd say go by those first two items. If the employee is gone for more than 3 days, or if the employee is hospitalized, it very well might be covered under the FMLA. Okay. It also covers serious health condition of a family member, and the family member must be a parent, a spouse, or a child. Okay, it doesn't cover siblings, it doesn't cover in-laws, it doesn't cover grandparents for serious health conditions, but it does cover parents, spouse, both same-sex and opposite-sex spouse, and children. Covers the birth and adoption of a child. And then it has two components that are related to military service. So it provides leave to care for an injured family member, again, who is a parent, spouse, child, or next of kin. If someone is injured in the military, then the employee, who is a family member of that individual, can have time away to care for that person. And then it also covers military exigencies. So that's if someone, if a parent, spouse, or child is about to be deployed, then there are certain reasons that the employee can take off under the FMLA as a military exigency. For the employee, if an employee is serving in the military, that's a different kind of leave. That is leave under USERRA, and that's covered by a different law. Okay, so we're just talking about medical reasons right now, which covers the FMLA and has those military components. But if the employee themselves is in the military, that's a different law that we're not going to talk about today in the seminar. And then I just want to note, on some occasions, the FMLA has been temporarily expanded to cover additional circumstances. So for example, at the beginning of the pandemic, certain employers were covered under an expanded FMLA that provided both leave and pay for that leave. So just something to be mindful of, that Congress occasionally takes advantage of this law to expand it based on circumstances that's happening in our country. So what is covered by the FMLA? So documentation. Employers are required to provide a notice of rights and responsibilities to an employee who's requesting leave. So this is an important component because a lot of times a employer may say, well, I know that the employee is not eligible for FMLA because they haven't been with us very long, or they're in a location that does not have 75 other workers. So they don't provide any documentation to the employee. But anytime the employer themselves is covered under the FMLA, then as soon as the employee says something about medical or military leave, you have to provide them with a notice of rights and responsibilities. The notice of rights and responsibilities is a document that all employers have to provide. And in doing so, it informs the employee whether they're entitled to FMLA and the length of time that they're eligible to use it. They're usually required to complete a medical certification. You do not have to do that, but the FMLA allows for that. So you can say, if you don't fill this out, then your job is not protected by the Family Medical Leave Act. Under the ADA, you could use that same documentation if the employee needs to go on a medical leave, but there's no law that says the employee has to fill out that certain form in order to be entitled to the leave. Okay, so that's an FMLA issue. Let's talk briefly about FMLA eligibility. So in order to be eligible for the Family Medical Leave Act, the employee must have worked for the company for at least 12 months. They must have worked 1,250 hours within the past 12 months, and they must work in a location that's within 75 miles of 50 other company employees. Now, as the manager, we do not advise managers to assess eligibility at all, because there may be things that you're not aware of, timeframes that the employee worked previously or worked under a different manager or in a different location that might trigger eligibility. There's also a provision of the Family Medical Leave Act that says that if you spend time in military service, that time may count toward your FMLA threshold. So a lot of times managers don't know if an employee has served in the military or if there's additional time that may count. And that's why it's important that Human Resources do that assessment. So what we recommend is for the manager, as soon as you hear military, medical, anything to that effect, then to contact Human Resources and not just leave it to the employee to do that. A lot of times the manager would say, hey, you may be entitled to leave. Why don't you go talk to Human Resource? And the employee doesn't do it for whatever reason. They think that they want to reserve their FMLA time, which they don't really have the option to do in most cases, or for whatever reason, they don't want to fill out the paperwork, so they don't go to Human Resources. So we recommend that a manager tells the employee, hey, you really need to talk to Human Resources about this. And then also the manager contact Human Resources directly to say, hey, I have an employee that informed me of this. They should be reaching out to you. If they don't, you might want to contact them. Okay, so what's the FMLA entitlement? FMLA entitlements are for 12 weeks in a 12-month period. Okay, and that's generally measured backward on a rolling basis. So at the time the employee needs leave, you'd look back to say, okay, how much have they taken in the past 12 months? Say they've taken 6 weeks of leave, then they'll have 6 weeks going forward. Okay, military caregiver leave is a little different. This is where the government has said we really want to take care of our injured military service members. So if you have a family member, again, a parent, a spouse, child who is injured in the military, then you are entitled to 26 weeks, so 6 months of time to care for that person. And again, that also covers next of kin. If the employee is the person who is listed on their military paperwork as the next of kin, then that individual is entitled to take military caregiver leave if necessary. The FMLA also allows leave to be taken intermittently. It's a small bullet point with a really big consequence. So what the law says is that if it is necessary for the person to take time off in smaller chunks, okay, so not 12 weeks of continuous leave, then the employer has to do that. So that equates to 480 hours of time. And this law is very black and white in the sense of if the employee is eligible, and if the reason for leave is covered under the Family Medical Leave Act, the employer does not have any choice whether or not to provide the leave. The Americans with Disabilities Act differs in that you can assess, does this pose an undue hardship on the employer? If it creates an undue hardship, you don't have to grant the time. You can say, I'm sorry, we can't accommodate that. We're going to have to end your employment. On the FMLA side, if the employee is entitled to it, and if the reason is covered by the FMLA, then that time has to be given and the employer doesn't have any option. Okay. So this is really ripe for abuse. A lot of employees abuse this law because they realize, okay, that's 480 hours that I don't have to work. If, I can present as though this is covered as an FMLA issue. So there are some tools to protect employers in the case of abuse. Some of them are getting a second opinion, or taking the attendance record to the medical provider to say, this is what the employee's attendance record has shown. Does this reflect what you would expect with someone with this employee's condition? Okay, so there's certain things that you can do, but most importantly, as the manager, what you should do is reach out to human resources to say, okay, I suspect this employee might be abusing medical leave, and I would like, you to look into that to the extent you can, and work with counsel to figure out if there are any options that we can do. Some examples of potential abuse would be things where the employee's condition happens to occur, on Friday afternoon every other week. That would be an indication that the employee is abusing that, because usually medical conditions don't happen with that consistency if it is something that requires intermittent leave. Be very cautious about looking at Facebook or any type of social media to assess whether the employee is abusing leave. A lot of times, employees will be on leave, employees will be on leave, and they'll post pictures of the vacation that they're on, or the time that, they're out on the canoe with their kids. And it usually makes coworkers upset, and they think, well, wait a second, don't you have a medical condition that's requiring you to be home? And the truth is that it may be both. Maybe they have a medical condition that prevents them from working, but they can do things with their family, or they can, do limited trips or something to that effect. So the caution there is to not assume that someone is abusing leave based on what you see on social media, but you could bring that to human resources to say, hey, there's something that just feels not right. This doesn't seem to be consistent with what the employee is telling me about their medical situation. Okay. So the leave does protect the job. That's the main point of the Family Medical Leave Act and for accommodations under the ADA. It provides reinstatement rights. So it says that after you are finished with your leave, whether it's the full 12 weeks or whether it's a shorter time that is certified by the doctor, or a longer time if you're providing leave under the FMLA and then under the Americans with Disabilities Act, the employee gets their job back. So either their exact position or their equivalent position, which means the same type of job, the same seniority, the same pay, okay, and the same benefits. The FMLA does require benefit continuation during leave. So health insurance needs to keep going, and the employee is still responsible for paying their portion of the premium. So that's something you can notify the employee of at the beginning if they're going to go on leave, as to, okay, how do they need to pay that premium and what are the dates that they need to pay it? And that's something that human resources should take responsibility of to make sure that that gets done. Under the Americans with Disabilities Act, there's no similar requirement of benefit continuation. So that's at the discretion of the employer, whether they want to put the employee on COBRA, which means that they end benefits and say, okay, you're no longer receiving benefits under the normal plan, but you have been put on COBRA just the same as if your employment was terminated or if you had another change in independence. So words to pay attention to. This one, again, are clues for managers and human resource professionals, supervisors. If you hear these words, that's when your flag should go up to say, okay, wait a second, we might need to get this employee to human resources to figure out if they're entitled to ADA. So baby, if someone says I'm having a baby, that's covered under FMLA, or I'm adopting a baby, or I'm adopting a child. That's something that should raise the flags. Any type of surgery, any type of hospitalization, medical issues. Again, we're looking at ones that incapacitate the employee for more than 3 days. Any type of military issues, or again, those clues of my doctor's saying this or my therapist is saying this. that's giving you some kind of indication that there's something going on with the employee on the medical front that the employer may have some obligations to address. Again, leaves of absence can be reasonable accommodations. So when we talk about the ADA, the Americans with Disabilities Act, we want to look at what the employee needs to enable the employee to perform the functions of their job. So leaves can fit that bill. Okay. Again, the purpose of the accommodation is to enable the employee to return and to do their job. They may exclude long-term or indefinite leaves because we are looking at, does this specific time period enable the employee to come back? So if you have a circumstance where the employee says, for example, Kate's back is bad and she can't sit in the chair for more than 20 minutes, so she cannot perform the functions of her job. She needs to be excused from work for 30 days, okay? And then I bring a note back after 30 days and it says, back still bad, we'll reassess in 30 days. Okay, you may say that is not an undue hardship to continue to hold my job. We can have a temporary person fill that spot. We can make that accommodation. So you may say, okay, let's give it another 30 days. Then they come back again. I say, my back is still bad. Can't perform the function of my job. We'll reassess again. At that point in time, there's really no definitive leave. It's becoming indefinite in nature, right? We really don't know when the back is going to be better or maybe never. And so in that circumstance, the employer does not have to keep going to provide an accommodation. Okay, so that's a balancing test that you'd want to work with counsel to determine, okay, is this to the point where this is becoming indefinite and we can't perform and we can't continue to accommodate this because there's no indication that doing so is going to enable the employee to come back. Okay. The company does not need to extend leave if keeping the position open would be an undue hardship. So that's where you look at, okay, is this coverable? Can we put someone in a temporary spot? Can we have someone do this work? What do we need to do to keep the business operating while the person's on leave? So that's something you can assess under the Americans with Disabilities Act, but not under the FMLA. Okay. The ADA, again, does not require benefits, so you do not have to continue paying for health insurance for that employee. And really, you want to look at the ADA if the FMLA is exhausted. So FMLA is the black and white, okay, gives a specific time period of 12 weeks. Are they eligible? Are they absent for a covered reason? And if so, that FMLA clock should start ticking from the very beginning. You need to give the employee the notice requirements. And then if FMLA is exhausted, so after those 12 weeks of time, if the employee still cannot come back, that's when you want to look at leave under the Americans with Disabilities Act to say, okay, can we grant additional time as an accommodation? And then, of course, if the employee is not eligible for FMLA from the beginning, that's also a circumstance when you want to look at the Americans with Disabilities Act. The FMLA requires the employee to have been employed for at least 12 months prior to taking leave. The ADA doesn't have that requirement. So an employee could come to you, and this is happening a lot where we're doing Zoom interviews or things where you don't see the applicant prior to bringing them on, and the employee comes in and says, hey, I need surgery next month, or hey, I'm pregnant and I'm going to have a baby tomorrow. Under the ADA, as soon as they're hired, as soon as they're employed, they are entitled to the protections of the ADA. So if the employee is going to be disabled for a certain period of time, you got to go through that interactive process and figure out if you can accommodate the employee without an undue hardship, okay, even from day one. And actually, it is a good thing that job interviews and things are done over Zoom where you can't see the employee and you can't assess, okay, might they have a medical condition? Might they be pregnant? Because that helps you truly assess just the qualifications for the role to figure out, is this person the right candidate, rather than basing the decision on a medical issue or on a pregnancy. Because what you want to look at is this person going to be the best employee in the long run? Even if we have to accommodate something at the beginning, if they need to be gone, if they're having surgery, if they're having a baby, Are they going to be the best employee for the company? And if so, then you want to bring them on, regardless of the need for leave. So ADA eligibility, again, there's no length of service requirements. So as soon as the employee starts, or even for an applicant, you may have to assess, okay, can we provide an accommodation without an undue hardship? So the only requirements are that the employee has a disability. So again, that's an impairment that substantially limits a major life activity, and that the leave would then enable the employee to return to perform the functions of the job, and that it's not an undue hardship. Okay, so as soon as the employee says medical something, you want to do that assessment if it's a new hire who hasn't been there for the required year in order to be eligible for FMLA. The employers can also grant discretionary medical leaves if the employee is not considered disabled. So just if, say, for example, the employee says, you know, I'm going through a tough time because my parent died, okay, and I'm grieving, and it's not a medical issue. I'm not disabled, but I'm in grief, you know, and I need some time away from work. Employers can always provide time if you want, okay? So discretionary leaves fall under most employers' discretionary leave policy. It may be kind of looped in with medical leave policies, and that enables the employer to say, yeah, take this time and then come back and do your job, okay? Most employees do not specifically say, I need leave as an accommodation under the Americans with Disabilities Act Amendments Act, right? Usually they just say, I have this going on, I need time, okay? I need time away, or I'm severely stressed, or I'm severely depressed. They will tell you about the medical condition, but not necessarily voice a need for leave. And the law says that as soon as someone says something to indicate in the employer, oh, this employee may need time, then the employer is required to notify the employee of their rights, okay? So to say, if they potentially would be eligible under the Family Medical Leave Act, you have to actually provide them that documentation. Or if not, well, you still have to provide them documentation if they're not eligible. And then you want to look to, okay, can we still provide time under the Americans with Disabilities Act or under our discretionary leave policies to just grant time away for the employee? So in assessing whether you want to grant that time, whether you can grant the time, again, this is if they're not eligible for FMLA, okay? If we're looking at ADA or discretionary leave, here are some of the things that you want to look at. So how much time is needed? Do they need 2 weeks or do they need 2 years? Okay, 2 weeks, I'd say most every employer could accommodate that. 2 years, probably no employers could accommodate that. Maybe they could, maybe you could hold a job for 2 years, depending on the nature of it. But that's something you want to look at. Is there a defined return to work date? Has the doctor said they just need X amount of time and then they can come back? Or is it a situation where the doctor says, no, we got to reassess. We got to reassess. Those reassessment statements from healthcare providers, that's really where you might say, okay, this is becoming indefinite and we don't need to provide the time. And then how easily can the work be covered by others? So can you have someone come in to say, to fill in the role? Can that be done fairly easily without a ton of training? Is the employee in a key position where you just can't spend the time training this individual to do this very high level work that only one person does, okay? If it's a very unique role, if it's a key position, that might not be something that you can accommodate to have the person be gone for an extended amount of time. So those are the things that you want to look at in assessing whether or not you can provide the accommodation. So other leaves of absence. So we've talked about the FMLA, we've talked about the ADA. Those are the big two that govern medical leaves at the federal level. So at the state level and at the local level, sometimes states have laws that require you grant time away. Sometimes they have sick pay laws that require you to be away. And some states have very unusual leave laws, like a law that says you can take time away to go donate blood or something to that effect. And so you want to be cognizant of what is applicable in your area, what the state provides and what the city provides as far as leave rights for the employees. Military leave is another leave that we touched on before that's generally governed under USERRA. That's the name of the law at the federal level that says if you serve in the military, your job needs to be protected for certain timeframes. Okay. Bereavement leave is another type of leave that is not legally mandated, but what a lot of employers have to allow employees time to grieve or time to attend funeral services for their loved ones. Jury duty, most states have laws that say you have to provide time away for an employee to go on jury duty. And a lot of states have laws like Nebraska that says you also need to pay them while they're gone. Okay, so in Nebraska, you have to both provide the time away and pay the employee if they are called to jury duty. Again, additional rights may vary by state. So different states, different cities have additional time away. And then benefit entitlements also vary by state. So some states may say, okay, not only do you have to grant time away for this purpose, but you have to pay the employee for that time. So that's like jury duty in Nebraska that says you have to grant the time and you have to provide the payment. And then there's a body of discretionary leaves that are provided by the employer. So those would maybe be found in employee handbook that says, okay, we're going to provide leave for these purposes. Or it may say we provide discretionary leave for a variety of purposes. If you need leave for any reason that's not covered under our other policies, come talk to Human Resources and we may provide it. So generally those are for things like a sabbatical. If an employee simply wants to, take a long trip or live in another country for a while or do something, engage in a course of study where they're just away from work for a long period of time, that might fall under a discretionary leave policy where the employer says, yep, I'm going to provide that just because I want to help enrich the lives of our employees. So what should you not do as a manager, as a leader, as human resources? What do we want to make sure does not happen in the workplace? So we want to make sure there's no penalty, no harboring of negative attitudes towards employees who need leave. Because the truth of the matter is that employees are generally more productive if they can take the time away to attend to their personal life, to care for family members, to care for themselves if they're ill. And so if they have the time to do that, they're going to be better workers. And most employees need that at one point in time. If you are able to go through your entire career with never needing a leave of absence, wow, most people aren't able to do that. And so to understand that, okay, this is a really common occurrence, this is something that people need. And so we're going to make these accommodations and we're going to figure out, how to work within the law, then you're going to be a better workplace or place to work. We want to make sure that we don't include references to legally protected absences in performance reviews. So this is something that there's a lot of cases on where a manager would write something like, the employee is attendance is fine, except takes intermittent FMLA and so is therefore gone a lot. Okay. And the concern with that is that if the employee applies for a promotion, or if the employee's pay is based on how well they do on that performance review, then a potential other manager who's looking at the performance review or when compensation is set, it's going to be based on something that's legally protected. So we don't want any kind of reference to that in any employment evaluations. Okay, so if you're doing an evaluation for an employee who has been on leave, what you want to do is kind of erase that from your mind while you're doing the review and figure out, okay, absent the time that they're on a protected leave, how is their attendance look? And then rate them based on that non-FMLA time or non-ADA time. And then you don't want to disclose one employee's medical condition to another. Now, certain exceptions apply regarding COVID-19, as we discussed, because OSHA does require you maintain a safe workplace. So there are circumstances where you may need to say, one of your coworkers has been exposed to COVID-19, or in an unusual circumstance, you may have to say this certain individual has been exposed to COVID-19. Again, that's the rare circumstance where you'd have to identify the individual. But this also comes into play when employees are gone for a long period of time, when they're on FMLA. And one thing that you can do here as a manager is to ask the employee's preference. And this is great to do over email because then you have a record of it that the employee said, yes, I want you to say this. So you could say, okay, while you're gone, do you have a preference on what you want me to tell your coworkers? Do you want me to simply specify that you're gone on a leave? Do you want me to tell them what's happening? If you have an employee who's has been diagnosed with cancer and is getting cancer treatments, sometimes they might want support and knowledge of their coworkers. So, or they might want their coworkers to have knowledge that they have this certain condition. So you can ask the employee to say, what would you like me to share? Is there anything that you want me to share beyond the fact that you're on a leave of absence? Okay. And usually using words like they're on a legally protected leave is all you need to say. That way the coworkers know, okay, there's nothing we can do about this. We have to pick up the slack, but this employee is not going to be here for, X amount of time. Non-retaliation. This is a really important piece, is that employees who have any medical condition or take a leave of absence cannot be retaliated against because of that. And it's sometimes difficult because coworkers may be angry that they have to pick up the slack, or that there's workload that's not getting done because of the employee's absence. But if you help your coworkers to understand, people are more productive in the long run if they have time to take care of their personal needs, and that we all may need to be absent at one time or another. That helps create a positive spin on it that will help employees just move forward and not retaliate against others who are gone. So make sure as a manager that you're not making slights, you're not making comments about employees who need to be gone on leave, nothing derogatory or even jokes about the employee being gone. So the internal leave of absence process, both employers and managers should notify the Human Resources Department if there's a need for a leave of absence. So as I mentioned before, if an employee says, I have something medical, I have something military, you want to advise the employee, please go talk to Human Resources about this. And then the manager should also go to Human Resources to say, this employee has identified, that there's X going on and they should be reaching out to you. But if they don't, please reach out to them. Okay. That way nothing falls through the cracks and the employer isn't failing on its obligations to notify the employee of what their rights are under both the FMLA and the ADA or any other applicable leave policy. Thank you for your attention. If there are questions, the contact information is on here, and happy to work with your Human Resource Department or your company owners to make sure you get your questions answered. And again, appreciate your time today.